You guys just want to argue with each other. And quite frankly, I don't have the time today to hear all this because this is just a mess. You guys can't get past your personal animosity toward each other to even look at this whole thing rational.
What you're about to witness is not just a simple landlord-tenant dispute. It's a full-blown breakdown of communication, trust, and basic legal understanding. Right from the opening seconds, Judge Simpson sets the tone. Frustration, impatience, and zero tolerance for chaos. This is exactly what happens when a case walks into court already emotionally charged instead of factually organized. Now look at the core issues buried under all this noise. Unpaid rent, disputed water bills, additional expenses, and a security deposit conflict. On paper, this should be a straightforward civil matter, but the moment personal animosity enters the equation, everything spirals. And that's what the judge is calling out immediately. Neither side is thinking rationally anymore. Pay attention to this dynamic because it's critical. And courts don't reward the loudest voice or the most emotional argument. They reward clarity, evidence, and compliance. So the real question becomes, who here can actually present a structured case, and who's just reacting? Because from this opening alone, it already feels like both parties are more focused on fighting each other than actually winning in court.
It's Lori Anderson versus Armani Lyman. State your name, please.
Lori Anderson.
I went back and reviewed the record, and what is clear in this case is I specifically indicated to both parties that they needed to be here in person. And she is not here, and the like. Did receive an answer. What is your claim? This is for termination of tenancy.
And a judgment, sir. Do you want me to read my
How much are you claiming is owed?
$1,139.94 as of today?
Hang on, 4,000.
$139.94.
All right, and that is for
nervous. July rent, which
the
is
amount of how much?
$330 plus late fees, which are $25 a day. So I calculated.
Can't do that.
This is where things get legally interesting, and where the judge immediately steps in to shut down a major mistake. The landlord is attempting to charge $25 per day in late fees, which sounds aggressive, but more importantly, it's legally problematic. Here's the key principle. Late fees in rental agreements must be reasonable and tied to actual costs, not used as a punishment or profit tool. When the judge mentions case law and liquidated damages, he's essentially saying you cannot create a penalty that's excessive or disconnected from real losses. That crosses into illegal territory. And notice how quickly the judge cuts it off. Can't do that. No hesitation. That tells you this isn't even a gray area. It's a clear boundary in landlord-tenant law. Now think about this from a strategic perspective. When one side presents an unreasonable claim, it weakens their overall credibility. Even if the landlord is owed legitimate rent, pushing excessive fees makes the entire claim look inflated. So here's the question. Is this a genuine attempt to recover losses, or is it an emotional reaction dressed up as a financial claim? Because in court, those two things are very easy to separate.
No late fees?
All right. I can't let you assess late fees at $25 a day. Okay. First of all, I think under case law, it would be an illegal late fee. Late fees have to be reasonably calculated to the cost of collection. That's not an exact science, but they certainly cannot be what would be called liquidated damages, which those would be. Okay. So, what months does she owe for?
July. I got a calculation. July, that would be $3,300 for July.
3,300.
Yes, sir. And
That's the rent?
yes, sir.
Okay.
And then I got the water bill, the water charges.
And how much was that?
Oh, let me see.
As the landlord starts listing out expenses, water bills, lawn care, court costs, you can see a pattern forming. This is an attempt to build a comprehensive financial claim, but the way it's being presented is scattered and reactive. Let's break this down. Water bills, for example, can absolutely be passed on to tenants depending on the lease terms, but the burden is on the landlord to prove accuracy, consistency, and fairness. And right now, you can hear hesitation, searching for documents, and disorganization. That's a problem. Courts rely heavily on documentation, not memory, not estimates, not, "I had it prepared earlier." If you cannot clearly present your numbers, it creates doubt, even if your claim is valid. Also, notice how the judge is patiently allowing this list, but only up to a point. And he's filtering what's legally relevant and what's not. That's why things like background checks or questionable add-ons get rejected quickly. This moment highlights something critical. Winning a case isn't just about being right. It's about being prepared, precise, and legally grounded.
I had it all prepared and I'm just,
How my day always runs.
what'd you say, sir?
I said that's pretty much how my day always.
I mean,
I have it prepared and then
I had it all in order. Now, find it. Oh, God, hold on. Okay, thank you.
You
Okay.
got it. Okay.
Okay, here's a order. Okay, court cost of $33.59. That's to get her served. Lawn care service of $35. She didn't pay. I had to pay for the lawn care service. Water bill for May of $207.29.
207.29.
Water bill for June of $230.32. And then extrapolated water bill for July 1st through July 11th today of $84.45.
Okay.
Then two cashier's checks that I had to get done because she, I don't know if you'll approve that, but that's $20.
Okay.
Background checks of $54.29 for her uncle, Augustus Lyman.
Why'd you have to do?
Because he's occupying my house and he's a criminal.
This right here is where the case starts drifting into dangerous territory. Accusations without relevance. The landlord brings up a background check and labels someone as a criminal, but the judge immediately shuts it down. Why? Because it has no direct bearing on the financial dispute at hand. Courts are not platforms for character attacks unless they directly impact the legal issue. And in this case, the issue is rent, utilities, and lease violations, not personal judgments about who's living in the property. This is a common mistake. When emotions run high, people start introducing irrelevant details, hoping it strengthens their position. But in reality, it does the opposite. It distracts, weakens focus, and can even annoy the judge. And you can feel that happening here. The judge is filtering aggressively now. Only facts that matter are getting through. Everything else, cut off immediately. So ask yourself, when you're in a legal dispute, are you presenting facts or are you venting frustrations? Because the court only cares about one of those.
Okay. I can't let you have that. All right. Go on.
And then, well, late fees, you said I couldn't have late fees.
Well, how much are your total late fees that you're charging?
I calculated based on today of 175, so whatever the court will allow.
175 for July.
Well, I calculated to July, to today's date.
Today's date.
Yes, sir.
Okay. So I'll allow you $50. Well, your monthly rent is $3,300.
Yes, sir.
I'll allow you $100 in late fees.
Okay.
Okay.
Thank you.
So what you need to do, and I will approve that judgment. Why don't you raise your right hand for a moment? Do you solemnly swear or affirm all the testimony that you have given and will give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And was there a lease on the premises?
Yes, sir.
Okay. But you're terminating the lease based on,
Okay, can I read my little
well,
spiel?
hold on, no. You can't. I just look at it. You're terminating it based upon the misrepresentations and also violations and fraud that you've stated to the court previously, in this case. as well as a misrepresentation, you believe as to identity,
Yes, sir.
and the person's in home, and then there is rent that is due. So based upon that and the defendant's failure to appear in this case, court is going to grant a judgment for possession to the plaintiff.
This moment is huge, and it almost happens without the defendant even being present. The judge is ready to grant possession to the plaintiff, which essentially means the landlord would regain control of the property. Why? Because the defendant failed to appear. That's one of the most critical rules in court. If you're not there, you lose your voice. Judges can, and often will, make decisions based solely on the available party's evidence. But then, suddenly, everything changes. The defendant arrives. Late. Very late. This is a turning point. Because now, instead of a one-sided ruling, the judge has to reassess the situation with both parties present. But make no mistake, the late arrival already puts the defendant at a disadvantage. It signals unreliability, lack of respect for the court, and weak preparation. So here's the question. If you were the judge, would you trust someone who shows up an hour and a half late to present a serious defense?
That's her? Okay. All right. She's here. All right. Come on up, ma'am. What is your name? All right. Ms. Lyman, it is unacceptable to be effectively an hour and a half late to court.
I submitted something for Zoom because I can't be late for work class. So I just came straight from school.
And I got off the bench and I specifically looked because I specifically indicated to both parties that you needed to appear in person.
I didn't receive an email of a denial of Zoom either.
When you guys were here on the record, I specifically stated that both parties needed to appear in person.
Okay.
So whether or not you filed a Zoom request or did anything along those lines, it wouldn't have mattered because I told you to be here in person. And Miss Anderson, I'll have to stop the inquiry that I'm making now that she's here. What's your position on this case, Miss Lyman?
Now we finally hear from the defendant, and immediately the narrative shifts. Instead of focusing on rent or bills, the defendant brings up lease confusion and personal discomfort. This is important. She claims she was asked to sign a new lease after already agreeing to one, and that's when things went downhill. If true, that could suggest miscommunication or even potential pressure from the landlord. But here's the issue. It's vague. Courts need specifics. Dates, documents, exact terms. Saying things went downhill doesn't establish a legal defense. It establishes a feeling. Then she drops another key point. She doesn't even want to stay. That changes the entire objective of the case. Now it's not about maintaining tenancy. It's about exiting the situation and resolving financial obligations. This is where negotiation could have played a role outside court. But instead, both sides let it escalate to this level. And here's something to think about. When both parties want out, why does it still end up this messy?
She asked me to sign a 3-year lease after I already signed a 2-year lease, and then this is when everything kind of went downhill.
Do you want to stay there?
No, not really. I already told her if she gives me my $6,000 for my cleaning fee, I've been stated that I will leave.
Is that the security deposit?
There's a cleaning fee and security deposit, but she never said that she would leave, sir.
So how much is the security deposit?
It's in the lease. And this is the first time I've seen her since she signed the lease on May 5th.
I don't care.
Okay. Oh. 5250.
And there's a cleaning fee, which is a non-refundable cleaning fee, I'm presuming, of how
Yes, sir.
much?
I have on video that she said that I could get my cleaning fee back.
What's the lease then?
Well, it's non-refundable, but I said if she leaves it really, really clean and, just like I had it, that I would be willing to, refund her that based on,
I
being
understand.
clean.
Okay.
This is a classic legal conflict, oral promises versus written contracts. The defendant claims she was told she could get the cleaning fee back. The landlord says the lease clearly states it's non-refundable. In almost every case, the written agreement wins. Why? Because it's documented, signed, and legally binding. Verbal agreements are incredibly hard to prove unless there's clear evidence, like recordings or written follow-ups. The judge acknowledges the oral statement but ultimately leans toward the lease. That's standard practice. Contracts exist to prevent exactly this kind of dispute. Now, here's the deeper issue. Both parties seem to have operated on assumptions instead of clarity. The tenant assumed flexibility. The landlord assumed strict enforcement. That mismatch is what created this conflict. Now, so ask yourself, when you sign a contract, are you relying on what's written or what was said? Because in court, only one of those truly matters.
Because
But the lease itself says it's a non-refundable.
yeah, because I think by law it has to say that. So that's why it says that.
It doesn't have to.
Well, I don't know. I'm not
A lawyer.
I'm not a lawyer.
All right. So otherwise, well, two things. First of all, with reference to I understand the oral representations that were made regarding the cleaning fee, but the lease would indicate that it's a non-refundable cleaning fee.
Yes, sir.
So,
Because I thought that's what I was supposed to.
and then with reference to the security deposit, that security deposit is can be used to pay rent, can be used for utilities and other things that may be outstanding. My understanding is that there are a number of water bills that still need to be paid. There is July rent that still needs to be paid. So, and I would have no way of assessing whether or not there were damages to the premises. So I don't know that that's a negotiation, but you say that you don't want to be there.
Well, yeah, because she has neighbors watching me, and it's very uncomfortable coming home, and there's people watching me.
All right, Ms. Lyman, let me ask you this. What do you want me to do on this case?
But really, I just want everything to be over. It's just the random people watching me, the false police reports.
So what do you want to do?
Say, I can move out in August.
When?
At least the 1st or the 6th.
Okay, and what about July rent
I was gonna put the rent in as well.
with the court? And that's $3,300? There is, as I was totaling and going through this, there's approximately, I have about $500, give or take, for the water bills.
I could have sworn water bills are supposed to come every 3 months.
I sent
I received one almost like every, and from the first water bill, I was only there for 27 days.
Can I make a comment, sir?
Sure.
I sent an Excel spreadsheet to the court and to the defendant that shows the water bill history for the last 3 quarters. I mean, 4 consecutive quarters. And it calculates a water bill based on my usage versus Mrs. Armani and her family's usage. And there's a significant difference. And I presented that to the court as well. That showed that she's using 3 times the amount of water with her family than I ever used. So, well, the police report indicated that there was a.
Just because it's people over there don't mean people.
There's really no reason for me to be here with you two, is there? Because you're just gonna talk over each other. And when you talk over each other, I'll be honest with you, I'm not even listening.
Can I make a statement, sir?
At this point, the case completely derails into accusations, identity fraud, impersonation, misrepresentation. The landlord claims she's never actually met the real tenant. The defendant calls it a lie. This is no longer just a financial dispute. It's turning into a credibility battle. And that's one of the hardest things for a court to resolve without solid evidence. Notice how the judge reacts. He disengages. He literally says he's not even listening when they talk over each other. That's a powerful moment, because it shows that behavior in court directly affects how your case is heard. When both sides lose composure, the judge stops seeing individuals and starts seeing a problem to manage. And here's the key takeaway. Even if one side is telling the truth, poor delivery can make it indistinguishable from noise.
You have. Go ahead. What is the statement?
This is the first time I've seen her since May 5th because an older woman who says she's Armani, she's at least 40, has been telling me she's Armani, but I think it's her mother, Joanna Lyman, and I've never been able to speak with her or see her. So I can't even talk to my tenant. I would have liked to have tried to work something out, but I'm not able to ever talk to her.
Yes.
That's a lie. She's seen me on multiple occasions. She doesn't even know anybody else who's ever met my mother. You've only met with me every single time. The witness statement about mail, I've never met that man. The mail has always been inside the mailbox. I've never met any of the neighbors because I don't even go confront people. I just go on about my day. So of course, none of them ever seen me but her.
And the fraud about the address that she said she lived at. In fact, she was living at a place on Maplewood she was actually being evicted from. And she told me she was living at Mr. Diop's house that's on her driver's license that he's lived in for 3.5 years. So that was the fraud and misrepresentation of the truth. She was actually being evicted when she moved into my house. And I didn't know this.
Well, there's a difference. Does she represent that she wasn't being evicted?
Well, she said that she was living at Mr. Diop's house, who's been there since 2021 and says he's never rented to her. So that's
What
fraud.
do you people want me to do? You guys just want to argue with each other. And quite frankly, I don't have the time today to hear all this because this is just a mess. You guys can't get past your personal animosity toward each other to even look at this whole thing rationally.
Judge, the phone number on her application was disconnected. I've not ever been able to call her and talk to her. For 2.5 months, it's been another lady talking to me on the phone and in person. I've never been able to talk to my tenant. We could have worked this out if she was actually talking.
Not the way you two are acting right now, because you're both acting like juveniles toward each other. You guys can't talk to each other.
I want to talk to her, not her mother. Sir, respectfully.
Yeah.
She asked for a past address. 9090 is a past address. I never told her that I rented from the lease.
Why do I care?
The application has 9090 on it.
You're just gonna keep showing it to me, so I gotta try.
I just want honesty.
She's only been talking to me.
You guys can't even resolve this, can you?
I don't even have her number, sir.
You have my number.
I don't have a number. You don't talk to me, sir.
8335 is my number.
You don't talk to me. I've
You
never.
know what? Both of you go sit down. These other people, I'm not gonna have them waiting through your mess. Go sit down. I'm gonna pass this case. No, I'm not even gonna pass it because I don't want you back up here right now. I'm gonna set this thing for a final settlement conference before trial. I'm gonna set it for this Tuesday. Oh joy. And then I'm inviting her back. So no. Go ahead. What time it's 9 o'clock this Tuesday, the 15th? Final settlement conference, July 15th, 2025, 9 a.m. That's in person. You need to be here. I will be waiting in courtroom A to hear your case and other cases with bells on.
The rent, since the mortgage is due, can,
9 a.m. on the 15th. I am not making a decision today. You are to put the $3,300 in the court escrow. Thank you.
thank you, sir.
She just said something. Anybody comes up and gives me a problem, you're gonna be. I see. What do you say? No.
This is the judge taking full control and resetting the case. No decision today. Instead, he orders escrow payment of $3,300, which means the rent must be deposited with the court, not handed directly to the landlord. This is a neutral move. It protects both sides. The landlord knows the money is secured if they win. The tenant ensures the payment is documented and not misused. And then comes the key outcome, a final settlement conference before trial. This is essentially the court's way of saying, fix this before it gets worse. Because if it goes to trial, both sides risk higher costs, stricter rulings, and less control over the outcome. Let's step back and look at the full picture. This case started as a financial dispute, but turned into a breakdown of communication, trust, and professionalism. Both sides made mistakes, legal, strategic, and emotional. The judge didn't just delay the decision, he forced them into a structured resolution path. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.